Welcome to another episode of the legal consequences of the coronavirus pandemic. Today we will deal with the question how employers should deal with the coronavirus pandemic. The pandemic has been particularly savage on employers. Its effect has been unprecedented and devastating. Employers everywhere have been forced to pay an unproductive workforce. Liabilities continue to mount. All current business has been deferred. Bank balances have been depleted. There is no new business in the horizon. Demand for services are dropping. Raw materials are difficult to come by. Creditors are clamoring for repayments. Some countries have advised reopening the economy. How should employers deal with their employment and business affairs at this time? We hope to explain in this video. This is a joint effort between Mr. V.K. Raj, an industrial and employment lawyer, and our team. Now, the tips here cannot be used for all industries or for all situations. How each business would need to respond depends on the nature of the industry, its workforce, its financial profile, and other factors which are peculiar to it. The building construction industry, the manufacturing industry, and the transportation business, all these need to deal with the issues differently, each according to its own peculiar circumstance. Some businesses cannot operate at all. For example, I have a friend who runs a restaurant. There's nothing he can do. So the entertainment industry is closed. So not all the tips here would help. Take what you need, leave what you don't. The first tip would be secure your workplace against further contagion spread. The converging workforce will create greater risk of contagion, sanitize the workplace, introduce easy to understand social distancing principles, and that's more important than clamoring employees. The second tip I would give would be to liquidate the assets and to reduce your financial incapacity, but that's obvious, isn't it? For you to liquidate your assets, first you must have assets. Secondly, they must be in a position to be liquidated. If the assets are diminished in value and cannot be liquidated, then this is out of the question. The third thing that you have to do is to prepare financial projections as proof of financial incapacity. Why? Now, preparing a cash flow analysis and a financial projection for the next 3 months, 6 months, 9 months, or a year would be crucial. The reason is, firstly, a good financial history and supporting documents and statistics would make it easier for you to apply for funding, whether to the government, to the commercial banks, or to new investors. Second, if an employer like you is dragged to the court by an employee, this evidence that you had prepared now with proper supporting documents would be crucial for your defense. The fourth thing that you should do is to demonstrate your own financial incapacity to your own financial employees. Now, before you start dealing with your employees, you must show that your employees, that you have no money, that the steps that you are taking are necessary. Now, once an employer understands your problem and that you're in deep financial straits, then he would be more receptive to your ideas. The fifth tip would be for you to negotiate temporary pay reduction with a guarantee of future repayment. If you are sure that future income is coming, then negotiate a lesser salary and guarantee repayment of that salary which hasn't been paid in a future time. This is, of course, one of the best strategies available. But unfortunately, if you have no future income available, this tip would not be very practicable. The next one is as good as the fifth. The sixth one would be to negotiate a reduction in wages. But before you do that, reduce the top management wages. It has a number of advantages. It will tell the employee what the current situation of the company is. It will demonstrate your good faith, and it has got a good psychological and practical value to it. You see, management wages usually form a substantial portion of the wage structure. Reduction of management salaries will actually lessen the burden on your employer, and the employee can see for himself that not only is his salary being cut, even his boss's salary is being cut, and that's a good thing. The next thing that you do, the seventh tip, would be to reorganize your workforce. The most important step a company has is to ensure its survival. Therefore, reorganization is a management prerogative, but it must be a genuine exercise. You must be able to show that your reorganization was bona fide, that it was carried out for valid commercial reasons. Now, if an employee drags you to court, and if he can prove that your reorganizational structure, that your reorganizational exercise was not genuine, but it was a sham, then the courts might, if the employee is dismissed as a result of the reorganizational exercise, hold that the dismissal of the employee is without just cause or excuse. Now, the next tip I would give you would be to enter into retrenchment exercise, but there are certain preliminary steps you have to take. Try and follow the Code for Industrial Harmony. It has no force of law so far anyway, but it has some influence. So the first thing that you should do is freeze or limit the recruitment of new employees, restrict overtime work for existing employees, reduce the work on weekly days of rest. This is usually very practicable in the manufacturing and service industries. Next, reduce the number of shifts or work days in a week. This is also a manufacturing practice. And the next thing that you can do is to reduce the number of working hours in a day. For example, if your normal working hours are 8 hours a day, you could possibly reduce it to 6 hours a day. Then you move to the ninth tip, which is the second stage of your pre-retrenchment exercise. If none of the above steps in tip number 8 are possible, then please, before you reconsider, in fact, exercising your retrenchment right, try and comply with the following sequence. Give early warnings, first of all, to your employees to say you will be made redundant. This will help the employees mitigate the losses and find other means of living. Now, in the same category of work, as a second tip, terminate the services of foreign employees before you terminate local employees. Then choose who would fall into the retrenchment list on the basis of last in, first out. The man who was last employed will be the first to leave. Now, you can depart from it, but you must show good reasons. Now, when the time comes for you to re-employ new workers, give your retrenched employees the first priority. My friends, I'm an employer myself. Times are bad. We are hard-pressed. We are going through a difficult time, but we want to help our employees. The government should help the employer. When employers prosper, the workforce finds a stable living. The economy improves, and the nation is put on a better footing. Only the government can do this. Only the government can help employers. The government should not come up with rules which are too stringent on the employees. What is the point of squeezing out employers just to sound very famous and favorable, and afterwards all the businesses collapse and there is no work? Thank you very much. This is all we have for today. I hope you enjoyed it. Please like, subscribe and comment. And if you like it, please share with your friends. Because when we see that there has been a subscription, that you like it, and you have said some favorable things, or you asked us some questions, then at least we know that we should make further videos and further instructions to help everybody in the country. Have a good day.